everything you do from the time you get the call, really, quite frankly, from 24 hours before you get the call, everything's kind of in play, you know. And you know, so as we go through that, you'll kind of find that a lot of stuff comes up, and you cannot. The big takeaway is you cannot prepare for court. And what I mean by that is you can't prepare court. You cannot prepare for court. No one can. But you can prepare to do your best. Attorneys that do not do well in court, they tend to be very intelligent. They are your very analytic type thinkers that are very cerebral. And they will go in and they will sit there and they will have a stack that high of things. They're gonna ask you about 921. And what will throw them off more than anything is if you look around and say, I have no idea. I learned that. I studied it. We referenced that. I'll have to reference my book. You just killed their entire legal argument. And they're 30 pages of prep. And they will fall apart. On the other end, you'll have some attorneys that don't prep at all. And they're gonna come in and you're gonna be more prepared than they are. And that's gonna kind of throw you off, because if I'm not prepared and you're on the stand, you're gonna have a tendency to wanna say more. Because I may say, hey, what happened on that fire on May 31st? You go, well, there was no fire on May 30th. And I'll say, okay, well, when was it? Which one? Yeah. And then you're gonna start talking, and then if I'm distracted or half-assed, I'm just gonna let you go. And it would be amazing on how much we overshare, even on you guys' end. So I'll get to kind of that stuff.
But doesn't, you know, because when you started in the fire service, it was always cause and origin. It wasn't really fire investigation. And then now.
So it's no longer cause and origin.
So now the company officer that's on scene, or the battalion chief or whatever, that's maybe doing a cause and origin report, the fire investigator comes in, it's all still part of the same thing now.
So now we determine origin and then cause.
Right.
And what gets really funny is last time we'd done one of these, I talked about it at arson detection dog, accelerant detection dog. That's not a thing anymore either. The terms on it, and we won't get into it too much tonight, but the scientific method. When we talk about this stuff, the scientific method is huge. And, you know, when we talk about arson, can you tell me, if you walk into an arson fire, you weren't there, you know it was an incendiary fire, how many scenarios do you have to rule out to determine it's arson?
You gotta go through a bunch of them.
So you could go through and I always hammer this, and I always tell my cops this: is it 5? Is it 10? Okay, you get called out to a fire. You're the investigator there. You determine through arc mapping it was non-electrical. You determine initially your origin of the fire. Your origin was here. Okay, well, that leads you to determine what the cause was. Okay, the cause was, it was incendiary in nature. There was, you know, a struck match, a hand lit this fire. Okay, based on what? Based on the scientific method. What does that mean? Well, I ruled out this, and this. Did you check the weather? Well, yeah, it was a sunny day. Okay, how do you check the weather? Well, I use weather.com. Do I have that report? Because I'm the defense attorney. Do I have that report? Well, no. Well, then it didn't happen.
Is it in your report?
Yeah, so if it's not in the report, it never happened. So you didn't check the weather. Okay, so we can't rule out weather. Was there a fire outside? Well, I don't know. You didn't rule out natural causes, you didn't rule out this. And so we'll get through, and maybe you ruled out and said, well, it wasn't electrical. There was no electric on in the house. I'll say, well, that doesn't matter. What if they had an extension cord plugged in? Maybe there was electrical from outside. Okay, well, we found fuel. Okay, well, what do you mean fuel? This Pepsi bottle, when I break it down, is a hydrocarbon, because it's got plastics in it. How do you know this, when it's melted, is any different than gasoline or diesel? You know, it gets really into, fire investigation is a very speculative field, and it is not a perfect science. Matter of fact, if you have a complete burn down, it's pretty well known that it's almost impossible to determine the cause of the fire. How do we solve most arson fires? Admit. People talk. Most crimes, whether it be arson or car theft, are because people talk. Even more are solved because not only do I talk, but I tell you, and then you tell him, and then he tells her, and then she tells her. People get caught because they talk. So it's really important when we nail these things down that we know that it is very important to Mirandize people, to have warrants and to go through, because you don't want to have Jesse say, well, yeah, if she tells me that Uriah told her that you lit a fire, is that admissible in court? It's hearsay within hearsay. But if she overhears you saying that, and she tells me, is it hearsay? No. It still is, because she didn't say it. So let's back up a little bit. What is hearsay? It is an out-of-court statement used to prove the fact of the matter asserted. I've used that since law school. It just simply means something you heard that somebody else said. It is not hearsay, though, if she observed you and you're dying and you utter it and you're like, I'm dying, I lit the fire. Exception to the hearsay rule. If you are excited and you say, oh my God, I just lit a fire, I'm on fire, blah, blah, and she hears it, she can testify to that. Or if I call her to court and she says, hey, Carrie was at that fire and I observed her doing X, Y, and Z. Her observation comes in that way. Court is very boring. It is very unlike what we see on TV. Jesse, you sit in it every day. It's terribly boring, isn't it? I mean, it is, there's no Perry Mason where at the end, they're like, I got a shocking witness. Very few times have I seen anyone get flustered on the stand and be like, that's right, I did it. The last trial we did, we kind of knew was going to be a winner. The one before that, I told my boss, I walked out and I'm like, you know, we lost. We took it to the jury and we lost. I'm like, there's no way they're going to believe it. I don't believe it. And I tried it. You know, me and her tried it. And the jury convicted them. And they got 104 years in prison. In the end, everything depends. And it's really hard to teach a class on it depends, it depends, it depends. But the big takeaway here on this stuff is that all you can do is the best you can do. All you can do is be careful, be methodical, use the scientific method, document everything. If you're not law enforcement, then don't act as law enforcement. If you are law enforcement, then act as law enforcement. If you occupy that weird role that is between law enforcement and fire, then walk that role. Take your time. It's always better to err on the side of, we Mirandize everyone. Why not? Has a case ever been thrown out because I Mirandized somebody and they didn't need it? No. Have cases been thrown out because we didn't Mirandize and we needed it? Yeah. It takes a minute to do it. Do you guys get to do that though? If you're not law enforcement or fire investment? No.
We just asked.
You just ask them to do it. Do you know what case does? So the cases they probably asked you guys is probably Brady, Giglio. I'm trying to think of some good examples in Missouri where we've had great cases. In general, the fire marshal's office will respond if there's a fatality, if they're requested by an agency,
or if a firefighter is injured, or a bystander is injured significantly, or if it is like a business and a significant amount of insurance money, or if it is a religious type entity that catches on fire. Most fires don't have a fire marshal come out. They don't call that. If you're in a city-owned department, it depends on, again, time of day and whether or not the crews are gonna call you. You guys still don't come to bread and butter fires, I don't think,
So,
right?
yes, we investigate all fires, however, if it doesn't appear that there's gonna be any evidence collected or any way to determine even a cause, well, an origin, if I can't determine an origin, because they've just eradicated everything and wasn't burnt to the ground, your investigation will be really short.
They still have, the crews dig out the fires or anything before you guys get there?
They shouldn't, but they do.
Old school methods die hard.
Cause I've requested that they would page, for working fire, they would page the fire marshal to begin the fire investigation part of it, so that you could get there and at least see it before it burned to the ground.
And that's a key takeaway too, you guys have cameras now in the battalion chief vehicles, right?
Yeah, some guys will have, department provides a helmet cam, just optional to wear, so sometimes you'll get some of that.
I like that, I think cameras in most cases allow and help more than they hurt. Cameras have definitely exonerated a lot of.
Actually,
safety employees.
several of the fires that I've worked on with Dale is, there's cameras in the neighborhood that, or people's home cameras. You know, a guy was charging an RC car, burned his garage down, and he had a home camera that showed the starting of the fire. But he thought it was damaged during the fire, but the file was uploaded to the cloud before we put the fire out.
So if we get, and we're gonna talk about some scenarios here to kind of wrap it out, and then we're gonna run some scenarios, but in that, if the neighbor has a security camera, and you go knock on the door, and they give you that camera, is that okay?
If they give it to you.
They give it to you, okay? If they give you that camera, do they have to come to court with it? Generally, in Missouri, we have the best evidence rule, and we have to lay a foundation. And so therefore, I have to provide to the court and the juror, the trier of fact, whoever that may be, whether it be the judge or the jury, the best evidence possible to show the crime was committed. If it were a camera, I would have to show the actual footage of that camera, not a USB drive off of it, unless I could pull it off the cloud or whatnot. That footage is technically not had a foundation laid on who it is, where it's from, who recorded it. In order to lay a foundation to admit it, because evidence has to be admitted into court. It has to be published to the jury and admitted. In order to do that, I have to lay a foundation to show what it is, where it was taken, how it was obtained. And so I have to have the owner of that footage in court to testify that it was their camera. They had set it up. It pointed this way from their house. It was this date and time, and that it was on that footage, and that's exactly what it shows. So in that case, I would have to have the owner of the footage come to court to show that. So, you know, interesting stuff. Now, if the owner won't give me that footage, what can I do? Okay, get a warrant or get a subpoena. Is there a difference?
I don't know.
So the subpoena is to, isn't it to gather
Evidence?
evidence, the warrant is with the crime.
So, again, when we get, if I have a fire victim, and I think they were intoxicated, and they go to the hospital, and the hospital does, you know, full workup through the ER. they're gonna have in their file whether or not they were drunk, what their blood alcohol was, and things like that. In order to get that, I'm gonna subpoena that record from the hospital. Or, I'm gonna get the defense attorney to allow me to request that record, and they're gonna consent to it. They're probably not gonna have to get a subpoena. If there's messages on Facebook, Snapchat, or anything like that, you're gonna have to get a subpoena to get those records. If the defendant or the accused party has it on his phone or has it on his computer, I'm gonna have to get a warrant because I'm gonna have to take his property and seize it. Interesting little stuff. Like I said, court does not work the way anyone ever thinks it does. So, like I said, we're gonna run through a few of these scenarios. Let's go back a little bit. So we've talked about the fact that we determine origin, then we determine cause of fire. We look at whether fires are incendiary or natural. Natural causes of fire, of course, brush fires, like, natural cover type fires due to whatever, lightning strike. That's a natural type God occurrence of fire, lightning strike stuff. Electrical fires, of course, those are gonna be known. Those origins are gonna be, pretty easy to find unless the house completely burns up. The cause is gonna be pretty easy to determine. The fire was in the electrical box and it was all charred up, and they had old buzz fuses and they hadn't been replaced and they had pennies shoved in. Pretty easy to determine. Probably not known to be arson. The other interesting thing that's a little bit different on arson is, in your packet here, I've included it somewhere briefly, maybe. I don't know if my secretary threw it in there when I had her prepare this or not. But there are, different rules. It is, it's right here. So in your packet here, we have toward the back, effective use of arson immunity law. And then we have 320.085. And 320.083. The first one I'm going to talk about is effective use of arson immunity laws is an abstract. All an abstract is, of course, I'm a tightwad, I'm not gonna pay to, access the journal and, gather that information. What I want you to take away is the abstract of that, which is kind of the overall point, the summation of it. Under arson immunity laws, insurer is required to report to the appropriate authority a fire that is believed to be non-accidental, and to provide official investigators access to all relevant information in the insurer's possession. Does anyone know what that means and why that is very important for what we do?
So they can disclose the information without being prosecuted.
And the big takeaway here is, I have a right. The best way to kind of compare it is something a little easier. If I'm on probation, I'm going to voluntarily agree to not go to jail. I'm going to agree that you can come in my house and drug test me and do this at any given point in time. I'm going to give up certain rights. And in turn, I'm not going to go to jail as long as I do that. It's kind of a win-win. I agree to waive these rights. You agree not to put me in jail. Normally, cops can't knock on your door and make you take a drug test. Normally, they can't say, hey, you can't go to the bar, where you been, or whatever. Okay, but in order to not go to jail as part of your contract for probation, you agree to allow them to do it without a warrant or without any stipulation. When you have a home, and I would challenge anyone in here to go look at their homeowner's policy. You agree to this in the contract when you carry insurance on your home. If you have a fire in your home, in order to get paid out by the insurance company, you agree to cooperate with their investigator to investigate the fire. If you don't cooperate with that investigator, then they just won't pay out your claim. That is a very powerful tool, because why do most people commit arson? There's a few reasons. Money. They get behind on their mortgage, they burn their house down. The economy gets hard, they burn their house down. They over-insure it, they wanna claim all the stuff was in there, they light it on fire. Most people commit arson during bad economic times, which we, have seen in the past, 2009, after the big 2008 deal. There's been errors where we get more arson fires than we've had in the past because people are in a bind, and they're trying to get out of that. Well, if they don't cooperate, they did it all for nothing. We can't probably prove it's arson, but then again, they don't get paid, and they kind of burnt their house down for nothing. Kind of tough luck on them, right? So, the other times people burn their house down is if they murder somebody in it, they got bigger problems. People will light fires to cover up crimes. What's gonna tip you off to that is the underlying crime. If you get into a fire and you find a body and it's not dead from being burned, and it has a bullet hole in it, you're probably looking at a arson fire. In Missouri, we recognize the felony murder rule, which means that if somebody is killed in the commission of a felony crime, major felony crime, then the people involved in that can be charged with felony murder, which can have capital punishment on it. So if two people go light a house on fire and commit arson, and one of them dies in it, the other one can get charged with his murder even though they're accomplices.
Well, that's those ladies up there that they were
Yep.
trying to get the old man.
Yep, the dad, what was he,
Yeah.
the dad or
The
something?
dad, and
Yep.
they set the place on fire and ended up killing somebody else.
Yep, and they all get charged with murder. So, if somebody's dead, look at arson. And if it is arson, maybe look at murder. Every now and then, we had one in Knoll a while back. The person went in there, they shot themselves in the head, and they had burnt their house down. They lit the fire and then killed themselves. Kind of weird. Luckily, we were able to look and see the gunshot wound was self. But again, look at that. And that kind of straightened me off. Arson immunity, again. If they're doing it, it's probably for money. If they're doing it for money, they're gonna have to cooperate or they get no money. Under the law of Missouri, we have statutes on point, because we have statutes that deal with about everything. 320.083, law enforcement officials will furnish fire insurance companies with information regarding fire loss. And it talks about that. I'm not gonna read that to you. The overall thing is, just remember on this one, the very last of that paragraph, on 320.083. No police chief, sheriff, fire chief, or other law enforcement agency shall disclose any fact, document, or information unless the request for blah, 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 blah has been approved by the prosecuting or circuit attorney having jurisdiction over that. So our takeaway from that is, we share it, but it's not your responsibility, it's mine.
Send it to the attorney.
Yep. 320.085, immunity, civil or criminal actions, in good faith, closed records. Again, this is just an assumption. We can't penalize people for working with the insurance company that deals with it. You guys can read that. The likelihood you guys have to deal with that is just slim. 320.081, kind of the same thing we talked about a minute ago. It just goes in the opposite direction. We just share information with them back and forth. Keep that in mind. They work with us. We work with them. Because they have a contract and they have to get that information, do they have to follow the same requirements as law enforcement Mirandize people before they talk to them?
Who's that?
The insurance company. Okay. Now, what if the insurance adjuster gets with you as the fire investigator, and you say, hey, I think Joe Blow's lying, I want you to go ask him X, Y, and Z.
What do they call it, working in cahoots or working together?
If you work in conjunction with that person, they are an extension of law enforcement, and therefore they would have to Mirandize that person, because if they give a statement, in that case, it would be inadmissible, because they're doing it on direction of the officer involved.
What if, let's just say somebody accidentally admitted to the insurance adjuster arson, but was unable, but let's say the fire investigators weren't able to find it, and the insurance adjuster was an accidental whatever, can the fire investigator go to the insurance adjuster and be like, hey, look, you need to do?
Absolutely.
He
Okay.
has to actually disclose it.
Yep, he would have to, he has a duty to,
Is that, he's legally has to, yes.
yep, because again, if he withheld that.
What's crazy is his report is required to go to the fire or the prosecutors.
Yep.
But my report isn't required to go to them, just to inform them that it occurred. And the attorney, prosecuting attorney has to review the information to determine what information goes to, is that correct?
That's correct.
Okay.
We would take that stuff, from the agency, I'll then review it for the pertinent information that we are required by law to disclose. And here's where it gets really interesting, on another level. And Adam's gonna be familiar with this, happened, but it wasn't it wasn't arson related. But it's record related. If he or law enforcement or an investigator files a probable cause affidavit to my office, to the prosecutor, can he as the fire investigator share that with the public?
Would that be public record?
Not until I file it. When I file it, it becomes public. While he's investigating it, it is not a open record. Under the Sunshine Law, records are closed if it's pending investigation until it's filed. Once it's filed, it becomes a public record, and therefore it can be shared. If he shares that before I file, if I don't file a case, why is that important? Well, it's really important because if Joe Blow, little town cop, is a dickhead, and he doesn't like you, he may charge you with a crime. Well, the prosecutor may say, well, I'm never gonna file this, it's ridiculous, you're just picking on this person. Well, he may then decide to call your fire chief and get you in trouble. He violated an open record, well, you can sue him for violation of an open record. The catch to that is that willful non-compliance with Sunshine Law and releasing a closed record is, last I looked, $1,000. You get $1,000. I can tell you it's gonna cost an attorney a lot more money than that to go after the record. But again, when we talk about sharing records, it is important to realize that. I won't get too much involved in it, but I will say that right now, this happens a lot. It happens a ton. You have to be really careful, us as public entities, and as firefighters. I'll just touch briefly on it, but there was a post by Carl Junction Police about people wanting information on an incident that happened. That's tricky. That's really tricky. There's no criminal charges on it. What can you post, what can you put out? Well, I can tell you guys, and for you guys investigating like arson or crimes, Facebook is never your friend. Putting things on the internet is never good, because you may run afoul into, you're providing closed records, or you are committing, at that point, libel. If Newton County had a case where the judge ruled the comments on Facebook, and it never got appealed, and there's no case law on it, but it does apply, because if you're in South Joplin in Newton County, you may get it in front of the county judge that ruled this. I watched a hearing where people were commenting on Facebook, and the judge granted a protection order, and he said these people felt threatened. He granted it against the people that made the post on Facebook, not the people that made the comment. And he said, well, you made the post, you could have deleted it. You have a duty to monitor what people are saying on your Facebook post if they're making threats to other people.
That opens up a whole.
I disagree with that and think that you have a right to post whatever you want on Facebook. But Facebook has also been ruled if you're gonna use that as a fire department to investigate and gather information, you either have to accept all comments that are made or turn off all comments, because you cannot selectively filter comments because you're a public entity. And so again, you have to be very careful, because you may post out and say, hey, we had a fire, did anyone see anything at 905 West 5th? And you may get 100 comments where people are like, F the police, screw you, I hate you, blah, 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 blah. I seen you take off with my sister, you had sex with my dog. You can't just go through and delete those. And so now, all that information is buried in a bunch of negative comments. And in the world we're in today, we don't want that. Like I said, I don't wanna go keep throwing around, you're gonna get sued for everything. This is not, you're gonna get sued for everything stuff. This is stuff, you're gonna make it where the prosecutor can't prosecute a case because you've tainted it. Big difference. Getting sued again is not a big deal. It really isn't. Everyone's terrified of getting sued. Who in here owns a house? I mean, I own a house. Okay. Who in here owns a car? Okay. Alright. Who in here owns multiple houses? Who in here owns multiple cars, classic cars or anything like that? Okay, so if I get sued, I can file bankruptcy and claim homestead, and they can't take my house, and they can't take my car, they can't take my wedding ring, they can't take a whole list of stuff. So, like I said, when we talk about getting sued, you really need to look at what all is exempt from bankruptcy claims. If you ain't got nothing, you ain't gonna get sued for nothing. Insurance will take care of it. But on the criminal end, you lie on the stand, you can be determined to be no use, ever. You're no good, you can't do your job, you're probably getting fired. On the criminal end, you cause harm, you can go to jail. On the end of, you're an investigator, and you cause problems and make posts on Facebook, and it's not civil, you made my job real hard. And I'm probably not gonna use you. And guess what? As the prosecutor, when you say, hey Tim, I caught this guy lighting a fire, I got a case on him, and I'm like, yeah, but you posted all that crap on Facebook, I don't have to file it. I have discretion in what I file. And believe it or not, that happens quite frequently. St. Louis County has had a major issue where cops have been put on the blacklist and they won't file their stuff. Oh, I worked a murder. Sorry. What do you think is gonna happen if the public finds out that you work for the fire department and every case you have gets turned in, gets denied by the prosecutor because you're a known liar? They're probably gonna call for you to get fired. Another example, I like to give examples. I had a guy in Jasper, Missouri. The chief of police over there had made a comment on Facebook about like Trayvon Martin or one of George Floyd or something. And it was basically to the point of, some people deserve to get their head stomped on or something. I was the defense attorney on it. I forget exactly what it was, and I don't even remember it was somewhere up there. And I went to the prosecutor and I said, hey, your guy's a witness. My guy claims he's lying, and that they don't get along, they dated the same girl in high school. And I'm like, do we really want to take this to trial and talk about what he posted on Facebook? Nope. I won. Case dismissed. End of story. So, use those tools sparingly if you're going to do this stuff. The last thing I'm going to talk about here before we get to our last scenarios, I included a little bit of a I'll call it like a Brady case law cheat sheet thing. I didn't really get into the other stuff here because again, I didn't want to bore everyone with case law. takeaway here is if anything's material, you need to turn it over. Notes, so this was brought up a little bit ago. Are you allowed, if you're the investigator and you're called to court, to bring in your notes? They should already have them. If they have them, they're probably gonna just bring them up to you and say, hey, if I'm the state and I wanna get out of you the information, I'm gonna say, hey, do you remember what happened on this day? No, I don't. I'd have to check my notes. He can't just pull out his notes. Now in our court, sometimes they do a little more laid back and they'll walk up with their police report. But the defense attorney already has a police report. But in more strict courts, I'll have to pull it out and say, if I show you this report and I show it to the defense attorney and I say, may I show it? And we all agree. If you read this, can you refresh your recollection of what happened? He's gonna read it and then he's going to paraphrase what's on it. He can't read from this. He can only use it to refresh his memory on what happened. He can't read and say, Brady v. Maryland, 373 U.S. 83. He can say, oh yeah, I remember in Brady versus Maryland, that's where they talked about material. Okay? Another big thing, again, is if you say it in preliminary hearing, if you say it in your report, you better say it in preliminary hearing. If you say it in preliminary hearing, you better say it in depots. If you say it in depots, preliminary hearing, and your report, you better say it in trial. Otherwise, you will be impeached. Impeachment is just the fact that if you're on the stand and you make a statement that is not correct, and I say, if Uriah tells me that a fire was on a Tuesday and it was hot out in his report, it was July 5th, and it was Tuesday and it was hot when we went to the fire. Then we go to Freeland and I say, tell me about that fire. He goes, well, it was on July 5th, it was real hot that day. And then he gets deposed and he says, yeah, I remember it was cold as hell that day. And it was on the 8th of July. During trial, I can say, okay, well, isn't it true that it was really cold that day? No, it was hot. Refer to my report, it was hot that day. I can pull back and I can impeach him. And all that means is that I'm just showing that he's not credible. He's not gonna get in trouble. They're not gonna punish him for that, but no one's gonna believe him. The jury is not gonna believe him because now I'm gonna say, well, isn't it true that here in your deposition on page 8, you said it was cold that day? Now you're saying it's hot? During preliminary hearing, you said it was hot. In your report, you said it's hot. Then you had a minute to think about it and it was cold. Now you're saying it's hot? Do you lie about everything? Well, no. Well, then why are you lying to us now? Why are you gonna lie to the jury? I don't know. So you're a liar. The other big thing that when we make it to court, if you're in depositions and you get called in and you take a break, depositions can go a long time. The rule on those now, I believe, is 7 hours with breaks in between. They can keep you there all day. If you are on a break and you go outside and the attorney hears you talking about the case on break, he can say, hey, we're on break. Court reporter, we're all gonna take a break. Let's take 5 and go to the bathroom. Then he hears you talking outside and you're like, yeah, man, this guy's a sucker, yeah, whatever. You come back in, he can put you in front of that court reporter and say, isn't it just true you called me a bad name? Well, we're on break. It doesn't matter. Did you or did you not? Well, yeah. Okay. If you come into depositions and you bring a notebook and you lay it on the table, that's your personal property. It's in depositions, right? I'm the other attorney. I can say, hey, what's in your notebook? Oh, my notes. Show them to me. No, I don't want to. Well, you brought them here today. That means you have to produce them. Well, I just got doodles in here and I drew a bunch of, willies on a notepad or something. I don't care. I'm gonna put stickers on them and we're gonna admit them as evidence. And you have to show it. So if you bring stuff in Or if you're in depots and you're bored, and you take your notebook, and you're doodling on it, I can say, can I see what's on your notebook? No, I'm just taking notes. Well, I'd like to see it. You gotta get it to him. And the attorney will say, well, the note says that the court reporter is ugly as hell. I'd like to admit that. Does it matter? Probably not in the grand scheme. In the defense attorney world, the prosecutor world, does it matter to the attorneys? Absolutely. When I am doing a case, part of what I do is based on the Constitution, the U.S. Constitution. Everything starts there. Your fundamental rights. Then federal law. Supremacy comes down. Maryland, Brady versus all that stuff, Arizona, Maryland, all that stuff. Whatever we got there. That rules. I gotta make sure I follow that. Missouri Constitution, Missouri law. Well then, how the Missouri Supreme Court has interpreted that law. How the appellate court has interpreted that law. It may say in here that on our arson, inhabited. Well, what does that mean? Well, in Baker versus Brown, the Missouri Southern District ruled that an inhabited structure means any building a person could live in. So a shed or what? Cardboard box. It's important as an attorney to know that. But I'm not relying on that during trial. During depositions, I'm not relying as much on that. I am looking at the elements and I'm trying to disprove the elements. It's my number one priority. As a prosecutor, my number one priority is to prove those elements. And I have to prove every element of every crime, and the lesser included if I want to do that, whatever is found, I have to prove every single one of them beyond a reasonable doubt. What's a reasonable doubt? It is what a reasonable person would believe is everything. Reasonable doubt is skeptical. If there's a big hole in my roof and a meteorite in my floor, I can probably assume that a meteor fell down and hit my house. But if I wasn't in that room, I could never be 100% sure. But I can know beyond a reasonable doubt that's what happened, because clearly nothing else could cause that. But there's nothing that is ever going to be 100%. A video of you stealing a truck, still not 100%, it could be altered, it could be angled, you could be wearing a disguise. Eyewitness testimony clearly can be wrong. Fingerprints, way wrong. DNA never comes back 100%, 98%, 99%. So reasonable doubt. But the attorneys are looking at those things first and foremost. After they get that and prove it, everything else is a show. In trial, everything they're doing is an act. A lot of attorneys are also very good actors. They practice acting. Matter of fact, in law school, they tell you to take acting classes if you can. When you dress for court, I can tell you, you have court clothes you wear that look different than what you normally wear. If you're doing a case and you're in McDonald County, you're gonna dress different than what you're gonna look if you're doing a case in St. Louis County, because you're gonna play to that jury. Everything at that point is an act. You're gonna prove your facts, but then the jury has to interpret those. And so, again, the little stuff that I said, well, it doesn't matter. He lied about something. Well, as an attorney, if I'm the defense attorney, my goodness, I'm gonna be flabbergasted. You lied because I got a jury. You lied about this, you lied about that. Just know that if you're the investigator on the stand, it's an act. What they're doing is to try and make you look less credible, so the jury doesn't believe beyond a reasonable doubt all the elements of the crime within that.
So does that mean as an investigator, you should probably act just a little bit too, but without lying?
So as an investigator, you want to go in and not act at all. You want to be the most stoic, real person that you can. If you're normally loud and obnoxious, be loud and obnoxious. If you're normally quiet and subdued, you want to go in and be exactly yourself. The attorneys are the one acting, and I can tell you if they pull it off wrong, they look horrible. If they pull it off right, OJ gets freed. Johnny Cochran was amazing on that. That is a great example of acting and how attorneys can act and do things and manipulate the court system to make people believe what they want them to believe. You, in your role, is to continue to be truthful, only answer what you know, stick exactly with it, and don't get flustered. In depots, I'm trying to make you mad. Preliminary hearing, I'm probably just trying to find out what you know so I can prepare for trial better because the standard's pretty low. In trial, I'm trying to make you mad. I'm trying to make you look like a hothead or a liar or whatever. I'm putting on a show. When I'm talking to you and you're on the stand, and the jury's over here, and I'm right here talking, and the judge is right over here, who are you talking to? Who are you having a conversation with in trial? The jury? The jury. So who do you want to look at in trial? And then make eye contact with the jury. It seems weird because you're talking to me and looking at them. So I'm over here, and you're asking me, and I'm looking at them. Take a minute every time you get asked anything. You want to take a minute and think about it and then answer. When you're on the stand and it's a trial or a preliminary hearing, you may be led or you may be directly examined. The difference between that is whether or not who can lead who. I cannot lead you if I'm the prosecutor. What does that mean? Well, first off, that's a lie because I lead people all the time. How much I'm allowed to lead people is how much the defense attorney allows me to get by with before they object. Leading simply means I direct you to the answer. So when I put you on the stand and you're my investigator, I'm gonna say, can you tell me your name for the record? How are you gonna feel? On this date, how are you gonna feel? Are you familiar with why we're here today? Yes, because of this fire. What was your role in that fire? Well, I'm this. Okay, how are you trained to do that? Well, I've taken a class, I'm certified, I'm designated by the fire chief, I was the first one there. Okay, what kind of training? Well, the standard for training is the IAI modules that we have to go through. We study 921, we study 1033. At the end of that, we take a long 40-hour course, followed by practical skills. At the end of that, there's a state test, we take that. I'm post-certified, which requires 800 hours of Missouri Law Enforcement Academy, followed by the post-test, whatever. Okay, cool. Tell me what 921 is. Tell me what 1033 is. Those are direct. You're just openly talking. You're telling me what I need to hear. Okay, so in this county, where did this happen at? You have to tell me who was involved, where it happened. Do you see the defendant in the room? Yeah, that's your suspect. Yep. Okay, can you point him out? He's right there. Okay, and this fire took place in our county? Yeah, it was at 905 West 5th. And that's in Newton County? Yes, it is. Okay, well, I started to lead you a little bit there because when I went from tell me what happened to was that in Newton County? It's leading. The attorney may let me get by with it, they may not. Okay, but if I'm the state and you're my witness, I have to do everything direct and open-ended. Your job on the stand is to only tell me the information I ask for. If I say, tell me your name, that's easy. If I say, tell me how you're employed, that's easy. If I say, tell me what you do, you're gonna look real dumb if you're like, well, Tim, on the weekends, I like to build model trains and da-da-da, because I'm gonna stop you and be like, that's not what I meant. Tell me what you do at your job. I investigate fires. How do you do that? Well, we use the scientific method. First, we go in and determine origin, then we determine cause of the fire. Okay, and how do you do that? Well, I do that by doing this. Okay, is there a standard curriculum that you follow? Well, yes, as a matter of fact, there is. Tell me about that. Well, it's this. Okay. The defense attorney can come up and he can lead you. And it's very, very impactful when they lead you. Because everything you said, everything you've been deposed on, everything that's been brought up, everything in your report, they can say, well, isn't it true They don't even have to ask you a question. They can say, isn't it true that you've never read 921 cover to cover? Well, yeah, I have. You've read the whole book, cover to cover. So if I ask you what's on page 92, you know it? Well, yeah. You have the whole book memorized? Yep. Okay, I'm gonna pull out my book. Tell me what's on page 92. Well, I don't know. Oh, so you just lied to me? Isn't it true that you just lied to me on the stand? And so you have a propensity to lie and make things up? I'm not even gonna let you answer as a defense attorney. I'm gonna just move on. And I'm looking at the jury, and I'm getting you flustered the whole time. And I'm like, well, isn't it true that you actually can't determine the cause of a fire, and that you can only rule out what it was not? Well, yeah, because that's a real thing. When you guys get into fire investigation, that is the number one thing defense attorneys are gonna ask you. Isn't it true that you simply ruled out possibilities and came to a conclusion that it was this? Yeah, but it could have been other things. Well, no, it couldn't have been. Are you sure? It could have been spontaneous combustion. That can't occur. Well, yeah, it can. You've been a firefighter for a long enough time. Is that magic? Is that something that occurs? Well, I've never seen it. But if I take oily rags and put them in a trash bin and let them soak, they can't catch on fire. Hay bales in a field that are put away wet won't catch on fire. You can't have an exothermic reaction. Well, did you rule that out? Well, no, there was no oily rags there. Well, is it because they burn up? Isn't it true? It's because they burn up. You didn't even look. It's very fast paced. It's very, very much like that in the real thing. Now, like I said, the likelihood of you getting a prosecutor that is just now looking at the case, or a defense attorney that is a public defender, that's probably more likely, and they're not gonna. The likelihood of you catching a prosecutor that knows how to prosecute arson, unless you get me or Jolie or a couple other people, is probably pretty slim. I would like to think that if the surrounding counties had a big one, they would call me because we all work together, and they would say, hey, Tim, that's the thing. Sometimes one county will get a case and they'll say, hey, come up and help us out with this. Prosecutors can prosecute in other counties. We can go up and assist and do stuff like that in general. There's some rules on that. Defense attorneys, same way. You're gonna have a few that only do this. If I were back in private practice, I would probably try and get licensed in every state I could, take my CD, and go out there and send it to all these insurance companies and say, hey, I have dedicated the last 2 years of my law practice to doing nothing but arson. I wanna come out and that's what I do. And so you may get someone that does nothing but this, but the likelihood is you get public defender guy and you got some homeless guy that went and lit a fire. And the likelihood is they probably confess. But this is the rare situation where you actually have to go in, determine the origin, determine the cause, determine what it could have been. Scientific method, that's one of the things that you're gonna be asked. If you're a firefighter and you're there, you're gonna be asked, well, are you trained to investigate? You're right, you came out on the fire truck, you were on the first new engine. You went in and destroyed all the evidence, isn't that true? Well, no, I put out the fire. Well, it's an arson case, isn't the fire the evidence? So you destroyed the evidence by putting it out. Then didn't you do something called overhaul? What is that? Well, it's where we go in and look for hot spots. So you look for them, like it's kind of look around, or do you take big metal objects and pull shit apart? Well, we take big metal objects, pull stuff apart. So you destroy everything around it. Yeah, but you're telling me you could determine the origin and cause by, well, yeah, clearly it was more burn here, and then I maintained the crime scene. Oh, is there a log of who went in and out? No. Okay. When we do our scenarios up north, what you'll find is that pretty well every case is a loser, because there's no perfect case. And unless you have a confession, you're gonna have a tough time winning these. And so your job as first in personnel on an arson is to document, be truthful, provide records, call in the appropriate additional help, fire marshals, work with law enforcement on investigative subpoenas and other material and work, and to do all these things together to help win the case. The thing is, you're not on trial. At the end of the day, what's the worst thing that's gonna happen? If they don't believe you, you lose. You think that, I always bring up OJ, but, I think we all pretty well know OJ did it. He won, first go around, lost in the civil. So, that's kind of the end of my class. I wanna open this part up for Q&A, and then, I'm gonna do a practical skill. We've been doing them as we go. One of the last practical skills is I'm gonna volunteer Adam and, show you guys what this looks like on the stand a little bit, from both ends, just so you can see it. But before we get to that here at the end, like I said, I wanna kinda open this up. We've talked about a hell of a lot of information tonight in a very short period of time. It doesn't track very smoothly because it kinda hops around. And it's, as much as I've worked and struggled to try and put this together as methodical as I can, it's very hard to go from talking about immunity to liability to torts to arson to whatever. So anything that we've talked about tonight, I just wanna talk about it here in class and have a discussion. It's kind of the opportunity. I can tell you, I talk to a lot of prosecutors around the state. I work with the Attorney General's office. When they come in and do cases, I have a pretty good barometer for how things are handled in Jasper, Newton, and McDonald County, of course. But, you know, the big takeaway is, if you're dealing with those people, I know in Jasper County and Newton County, talk to your prosecutors. If you're working these cases, go in and, sit in court. If you're bored, come to McDonald County and sit in court. Jesse will tell you, you get me, 99% of the time. I do probably 99% of our hearings down there until we go to trial. If you wanna see what a preliminary hearing looks like, you can't be in depositions, of course, but, preliminary hearings, motion hearings, you know, I highly recommend that you come in and see how it's done. I highly, highly recommend looking at the NFPA guidebooks, the guidelines, the standards and things like that, the outside material. And then again, like I said, picking everyone's brain. Don't not do your job because you're afraid to get sued. That's the other big takeaway here. You know, don't let attorneys scare you into thinking that you're gonna end up getting sued and losing everything. Do what's right, regardless if it's running a call or investigating a fire. Be as honest as you can. And, you know, if you're honest, your story will stay the same. If you don't remember something, tell them. If something's off, say something. If you're running a call and things are off, say something. If you're on a crew, talk to your crew about what's going on. If you got young guys on your crew, tell them, because there's a strong likelihood, unless you get stuck with my poor kid that gets harped on by me all the time, a lot of these young firemen don't have any idea of anything about anything. And, they don't know what to do or not do. They don't know who to talk to or what to say, or, you know, if they go out on a call. The big thing, you know, aside from the fire department, if you're on EMS, don't go around saying you either go with them or go with us, cause you can kidnap people. Fire department, you have no influence, you're not cops, unless you're a fire investigator, and then you're a cop. But if you're working on a truck, Good Samaritan law also applies to anyone that calls in a drug overdose, cannot be charged with a crime for the drug possession if it's a true emergency. So I always get mad at firemen, because I'll have firemen on calls that'll like show up on the fire department and be like, well, Joe Blow called, they got meth over here, and they'll tell the cops about it. It's not your job, you're not a cop, unless you're an investigator, and then you're a cop kind of deal, so. Like I said, this is more 2 classes put together that I'm trying to get a feel of by the feedback form and the little quiz that we go over that'll take about 2 minutes. What people wanna hear more of as we develop this, and I continue to develop it and try and get post credit for it. I imagine the feedback's gonna be not so much about the legal essentials part, more about arson stuff, cause it's much more compelling. You know, or maybe people wanna know a little bit more about legal rights. I could teach a whole day on fire districts and their duties and their board. I could teach a whole day on, you know, cities and what they're required to do to contract fire service. I could teach a whole day on human resource and, EEOC and Missouri Labor Board stuff. So, you know, again, this is kind of feedback for me to give to the state, on what works and what doesn't. So, but again, any questions here that we wanna talk about in the whole mess of everything that we went through tonight? Without PowerPoints, it's really, or videos, like I said, this is a hard class to instruct.
Well, there's just a lot to it.
It's a lot, it's more homework and more, hey guys, think about this. The takeaway here is, think about this stuff. And when you get in a scenario, just take a minute, take a breath, and think about it. Think about what you're gonna be judged by, not about the rumors you've heard at the fire department, not about what, you know, you've heard about, oh, I'm gonna get sued, oh, I'm gonna have this, oh, I'm gonna have that. Just step back and say, hey, how can I act? Is it appropriate for how I'm trained? If the answer is yes, then you're gonna do the best you can. If you do that, then like I said, you may get sued anyway. Hell, you could mess up everything and not ever get sued. Or you could do a perfect job and get sued. There's no rhyme or reason, to that. You know, it just happens. People have access to the court. Crackpots go in and file stuff on their own all the time. I had somebody come to my office and wanna hire me to sue Donald Trump one time when he was president the first go around, because he had said something on TV and it offended him. And that person had filed like a pro se thing in federal court or something, and they're like, hey, can you help us? No, I can't. Sorry, I don't know what to tell you, so. Again, you know, if you guys got anything, what we'll do is, like I said, I wanna do one scenario, I'm not gonna make everyone go through this little practical. You guys have all, part of the practical is, we discuss scenarios, talk about them, I give you questions, you guys give me answers on how you would react. The last practical for time is, again, I'm gonna kinda walk through. What I'll do it with, two different views, I just won't single out at them. I'm just gonna kinda question you as if I'm the state, and what that looks like if this were to go to, say, a prelim or a hearing. So, again, what they're gonna do is you've been brought in, for our scenario here, you're just the investigator on fire. The fire occurred on November 5th, 2024 in Newton County, Missouri, and it was an arson fire. The guy admitted to it. You get there, single family home, the guy was behind on his mortgage. You determined that after he investigated it, he had taken out a big insurance policy, had just left his wife, went in there. Fire crew gets on scene, the house is burning, he's there, claims he doesn't know how it started, he's got burns on his hands. You talk to him, he voluntarily tells you that, you know, he got behind on his house, okay? So that's our scenario for this, and like I said, I'll show you the state end of how that would look, and I don't expect you to get everything right. So the first thing he's gonna do, again, if it's prelim, there's gonna be a court reporter in there, or court clerk. Generally they record stuff. If it's a court reporter, they're gonna have a little stenographer's mask on. Otherwise, if it's like prelim, the attorney may record it, or it may be just recorded in the room and have a sound recording. If it's got a sound recording, there'll be a little clock, and the little clock will turn red, and that's how you know you're being recorded, and there's microphones. You're gonna come up every time you're gonna swear, you swear to tell the truth, the whole truth, so help you God. I do, okay? And then you're gonna get on the scene. The attorneys have already talked, they've already invoked the rule. When they invoke the rule or talk about this stuff, all it means is, no other witnesses are gonna be allowed in the courtroom until after they testify. So it's only gonna be you and people that have already testified in there. If you're the investigator, you're very likely gonna be the first witness that the state would call. We're gonna have prepped you beforehand, which means you're gonna sit down with me beforehand, and I'm gonna tell you exactly what I'm gonna ask, okay? So you come in, you're sworn in, okay, you swear in. I come up, Alright. For our record, can you state your full legal name?
Adam Lane Grimes,
Okay. Mr. Grimes, how are you employed?
work for the fire department job.
Okay, Joplin Fire Department, is that a paid fire department?
Yes.
Okay, so you're a career firefighter?
Yes.
How long have you been a career firefighter?
22 years.
And as a career firefighter, what does it take to become a career firefighter? What kind of training or skills do you have?
Initially, I had no training, and then sent me to a school to learn how to do firefighter 1 certification and firefighter 2 certification. Following those successful certification tests and practicals, emergency medical EMT license, same similar process, a class, along with the test, practicals.
And those certifications, again, you take a standardized state test to get fully certified, correct?
Yes.
And there's additional training you can take as a firefighter?
Yes.
And what kind of other types of training can you take?
Well, you have continuing education training for your medics license, and then you'll have, continuing education for firefighter, or you can take additional training for promotion.
And you're also a fire marshal. That's a different kind of firefighter, right?
Yes.
What does that mean?
So, in Joplin, you have to have a inspector certification. Once again, test and practicals and standardized curriculum.
Okay.
And then from there, within 1 year, you can become an investigator,
Okay.
certified with state Missouri.
And as an investigator, again, is that like a cop, or is there any specialized training? What does that look like to become an investigator?
So you have a standardized class that will go over the JPRs, which are in NFPA 1033. You'll have practicals along with the standardized tests.
Okay. And so, that kind of brings me to why you're here today. Of course, do you know why you're here today?
Yes.
Okay, it's because of an incident that happened on November 5th, correct?
Yes.
Okay, can you tell me about what that was?
It was a fire that occurred at it was a single family home. And I was called to investigate.
Okay. And so, I know I'm gonna kind of skip ahead,
Sure.
because I don't wanna run out of time, but during that investigation, do you recall the address? Okay, if I show you your report, would that refresh your memory?
Yes.
Okay, I have the report, and I showed it at 905 West Fifth. Okay, and that's in Newton County?
Yes.
Okay, so Newton County, Missouri, now did you identify a suspect in that? In this case, we have the defendant.
So initially, no. The individual who's the suspect today, in my report, I indicated that we had confessed to being on scene and having started the fire.
Okay, and that suspect is Mr. John Smith here. Is he here with us today?
Yes.
Okay, can you identify, and I show, you identify, tell me if he's wearing clothing. Okay, he's wearing a blue hat.
Yep.
Okay, clerk, please show identification of the defendant. So, again, you've identified the defendant. Were you able to determine the origin and cause of fire?
Yes.
And then you would tell me about that, and then, I would say, okay, and based on the statements made by this individual, you determined again that this was a single-family home, so was it inhabited?
Yes.
And of course, the defense attorney may object at that point, because I'm starting to lead you a little bit, though. Okay, so it was an inhabited structure, and he caused the fire. Was it on accident? You know if he did it accidentally, or if he mentioned that he did it on purpose?
He indicated that he had lit the fire.
Okay, so an incendiary type fire. So this in fact was an arson fire.
Yes.
And so again, now I've taken what he's given me. If we're prelim, I'm sold. Okay, this is done. I've showed the court that it's more likely than not that the defendant that we've identified in this county met the elements of the offense.
Correct.
If it's a trial, we're gonna go a lot longer, but again, that's kind of where we're gonna start. We're gonna talk more about his training, more about his experience, more about his record, things like that. Okay?
And then the other side, their job is to discredit you, correct?
So, and we'll do, okay, Carrie, same deal. You've answered everything Adam has, but now I'm the defense attorney, okay? Alright, Mr. Grimes, and they may even be real derogatory toward you, they may be real respectful, and it's whether or not, if it's prelim, they're probably gonna be real laid back, cause they know they're sunk at this point. If it's prelim at this point, all they're doing is gathering up more evidence, because they're just trying to know where they're gonna go during depots, or where they're gonna go during trials to try and shake you up, and they're just digging a little bit more, cause it's pretty more, it's lax. But if it's trial, and I know that you're volatile, I may try and shake you up. Okay, I may say, okay, Mr. Grimm, you'll be, well, it's a crime, you know, whatever, they'll do stuff like that. Believe it or not, they actually will do stuff like that to try and get you ticked off, to see how you're gonna respond. They also may be objecting while I'm asking questions to throw you off. Because if they object, you have to immediately stop. So if you're in the middle of talking and they object, you have to stop right away and allow the attorneys to then argue. And they'll go up to the judge and they'll make their arguments and they'll come back and the judge will either say you may, overruled or sustained. Overruled means that, go ahead and finish. Sustained means I'll have to rephrase it. Okay, so Mr. Grimes, you said that you're a fire investigator for the city of Joplin, correct?
Yes.
So, you're not a cop, you're a fireman, isn't that right? So that basically means that you're not really trained in how to investigate, you're trained in how to put out fires, correct? So you don't know how to put out fires?
Well, I do.
Okay, so are you trained to put out fires, or are you trained to be a cop?
Oh,
Well, you're a cop, you're post certified.
really? I don't know.
Right.
That's
See,
his point.
see how easy that is? I'll do, Jesse, you wanna take a go? You're in court with me all the time.
Yeah.
Alright, you can be Adam, so, Mr. Grimes, isn't it true that you're a firefighter and not actually a police officer?
That's correct.
Okay, so you don't have the required training to investigate an arson like this, or how to interview witnesses or anything like that, isn't that correct? I mean, you never attended Post Academy to learn how to actually not violate my client's constitutional right, correct? You never attended, so you don't know what his constitutional rights even are, correct? You're just a firefighter. You're basically a firefighter with a special job. Okay, so you and I both can agree on the fact that you actually have no law enforcement training and have no idea how to actually interview my client. And so everything we're doing today is pretty well effectively pointless, correct? You don't even have to answer that because I know the answer. You've already told me you're not a cop. So you're trained in this one class to investigate fires, and all of a sudden you can determine what caused the fire. Isn't it true though that scientific evidence shows that you actually can't determine the origin of fires?
I would have to agree with that.
Okay, so you agree that actually, since you can't interrogate my client correctly, and John was as out minding his own business, losing his house, you come along, you jump down his throat, you scare him, you're wearing this fancy uniform, he thinks he has to talk to you, you scare him into telling you what you want him to tell you, but you have no further proof that he even caused this fire? Isn't that correct?
Right.
No, nothing further. Get what I'm saying? That's what they're gonna do on this stuff, guys. So, again,
So pretty much, it's like once they back you into a corner.
hey, you've seen this in court.
Yeah.
I mean, Dwayne Cooper's the king of that shit. He did it to me today and really ticked me off.
Well, that's what I'm saying is, you just have to answer the question.
But
That's
that's it.
what's hard,
Yep.
is, I know where you're going, but I can't stop you.
Yep. And, if you get mad, the thing is, it's a hard line to walk, because if you get mad, the jury's gonna be like, oh, wow, he really flustered you. If you're like, right, and you get, like, if you downplay it, they're gonna be like, well, he doesn't even take his job serious. So how do you walk that line? I don't know, and unfortunately, like I said, Adam's gonna get 2 days of this stuff, which is, like I said, really, really fun stuff, so. The last thing we're gonna do here, because we have bought all our time, I did a quiz here. We're gonna go over it together. And it's really, really easy. If somebody wants to, go through number 1 for me real quick. And we'll just all come up with the answer together and kind of gauge.
The following best describe the role of the fire protection district in Missouri.
So we didn't really hit on that much, but it should be self-explanatory, I kinda jumped at. B, we all agree it's B? Fire Protection District is, they're no different than a municipal fire department, except they're governed by a board instead of the city council. They contract to do fire service. We touched on that a little bit, but again, no one in here is on a fire protection district, so we kinda jumped ahead. Alright, number 2, what is the primary purpose of the Good Samaritan law as it applies to Missouri firefighters? Can we all agree on B? Alright. So the correct answer is B, and B is to protect firefighters from liability when providing aid outside of official duties. So again, we talked about that. The only problem is if you get hurt during that, you kind of avail yourself to the injury, and so you can't come back and sue the victim. So you rescue at your own peril. And I think I mentioned that, if not, that's important. Number 3, letter 3, under Missouri law, which of the following is true regarding vehicle accident liability for fire department personnel? C. We'll agree on that one? Alright, what is C?
Fire department vehicles may be liable if negligence is proven.
And interestingly enough, one of the things that is in our sovereign immunity statute is the operation of a vehicle. It is exactly one of the things the statute talks about, where we can be held liable, is operating a vehicle. So we're probably more at risk in that. Alright, number 4, the public duty doctrine is designed to B. Again, it's just that statute is designed to protect government actors from being sued. A lot of people don't like the government and they want to sue everybody, and it's to kind of protect us from those people that are going out of their way to do that. Alright, we got some matching stuff. Just kind of match everything together. That was pretty easy. Good Samaritan. Like with B. Alright. Fire Protection District. And then Public Duty Doctrine. You paid attention to the ones before. I didn't have to make the test hard, I just had to make the test. Alright, then fill in the blank. Alright, what do we think the first one is on phone?
Good Samaritan law.
Good Samaritan law. Number 2, what do we think that is? Yep. Number 3.
Public duty doctrine.
Okay. Number 4.
Negligence.
Negligence. Yep. Negligence is a tort. That goes back to our duty, cause, breach. Duty, breach, cause, and harm. So that's that. All that material is for you guys to take home. It's probably more than you'll ever want on case law or, well, statutes anyway. But again, it was stuff I thought was probably pretty relevant for you guys. And then, like I said, the big thing, and the only thing I really need is the evaluation form. That way I can hopefully get something developed that'll be a lot more than this one. I appreciate everyone bearing with me on this bear of a class. It is, like I said, a very dense and boring subject matter. It's not fun. It's been 4 hours worth of not fun. But hopefully we can key in some of that stuff for when we prepare the next one.
I think it's back here.
Great way to spend the evening, huh?
Yeah.
Talking about court away from court.
I'll tell your boss that they need to give you,
Yeah, tell her that I need the afternoon off.
I'm sure she'll listen to my opinion. I think we've determined no one at the courthouse listens to my opinion.
till they need it.
Join the club.